Today we'll be going over 10 of the more overlooked terms for your real estate exam. Our first term is abstract of title. An abstract of title is a certified summary of the history of a title to a particular parcel of real estate. It may include the original grant deed and any and all subsequent transfers, encumbrances, and releases. In other words, an abstract of title is a written history of all the recorded documents that's related to a specific property. Our second term is chain of title. The chain of title is the recorded history of conveyances and encumbrances that might affect the title to a parcel of land. In other words, a chain of title is the sequence of historical transfers of title to a property, whereas the abstract of title is just a certified summary of all the history of a particular parcel of real estate. A chain of title is most commonly used as a tool to identify and document past owners of a property and serve as a property's historical ownership timeline. This chain typically runs from the present owner all the way back to the original owner of the property. Our third term is marketable title. A marketable title is title to a property that is free from encumbrances and reasonable doubt, and that a court would compel a buyer to accept. Basically, a property without an imperfection or cloud on its title. Speaking of title, our next term is junior mortgage, or a secondary mortgage. A junior mortgage is any mortgage that is inferior to a first lien position, and when a foreclosure comes about, will only be satisfied after the first mortgage. Now, some home buyers typically require one mortgage to purchase a home, while other home buyers require two, the first mortgage being the primary lien, and the secondary mortgage, or junior mortgage, could be some type of down payment assistance program or even a home equity line of credit. Our next term is agency. This one should be straightforward. It's the legal relationship between principal and agent that arises out of a contract wherein an agent is employed to do certain acts on behalf of the principal who has retained the agent to deal with a third party. A primary example of agency would be a realtor employed by a home seller to deal with a third party such as a home buyer. Now, moving right along, our next term is procuring cause. Simply stated, the action that brings about the desired result. In terms of real estate, if a broker takes actions that result in a sale, the broker is the procuring cause of the sale, which equates to the broker getting paid his or her commission. Term number 7 is implied contract. The implied contract is a contract where the agreement of the parties is created by their conduct or actions. Now, in terms of real estate, let me give you an example. If a real estate agent reasonably appears to be acting on behalf of a seller or a buyer, doing things such as negotiating for a price, doing contracts, answering phone calls for the buyer or the seller, then we can reasonably assume that the agent acting on behalf of the buyer or seller is in fact their agent, even though they don't have a written agreement between themselves. The next two terms are power of attorney and quitclaim deed. Let me define the two terms and give you an example. Power of attorney is a legal document that authorizes someone to act on another's behalf. A power of attorney can grant complete authority or can be limited to certain acts and or certain periods of time. Now, a quitclaim deed is a conveyance where the grantor transfers without warranty or obligations whatever interest or title he or she may have. Now, a common example of quitclaim deed is in community property states. If a husband and wife purchases a home, their names will be on title. Now, for example, if the wife does not want her name to appear on title, she will have to execute a quitclaim deed. Once executed, her name will be off the title and the husband will own 100% of the property. Now, what if the wife is out of state, or she may be out of the country even? Then the wife will have to execute a power of attorney, which will allow someone to execute the quitclaim deed on her behalf. However, this will greatly depend on the state you're in, the escrow, the title, and any other regulations your state may have. Our last term is riparian rights. Simply defined, the right of a landowner whose property is adjacent to a flowing waterway such as a river to access and use the water. This term is pretty simple and straightforward, and this graphic should clear up any confusion you may have. And this concludes our video. Thank you so much for watching. If you liked it, please subscribe, like, and comment, and we'll see you next time.